Right, so a very warm welcome to our first 3CL seminar, starting our Michaelmas term for 3CL, the Center for Corporate and Commercial Law. I'm very pleased that we've got both people here in the room and online. We actually have more online. I think our announcement that we could only have 30 people here in the room may have nudged people to join online. So in the name of my co-director, Professor Louis Scalifer, who is here in the room with us, and myself, I'd like to open our seminar series. And we are very, very happy to have Professor Katharina Pistor here with us, joining us from Italy, perhaps Rome or another location. Perhaps you can, if you wish, so to disclose this, Katharina, but I'm not pressing this point. Katharina is the Edwin B. Parker Professor of Comparative Law at Columbia Law School and Director of the Law School's Center on Global Legal Transformation. Her work spans comparative law and corporate governance, law and finance, and law and development. She is the co-recipient of the Max Planck Research Award in 2012. She's received that, a member of the Berlin-Brandenburg Academy of Science, and a fellow of the European Corporate Governance Institute. Her most recent book is The Code of Capital, How the Law Creates Wealth and Inequality. And I always wanted to hear her speak on this book, and that's why I'm personally very, very happy that she accepted our invitation to speak on this book today. As always, we'll have roughly kind of a 25 to 30 minutes presentation by Katharina. She will share slides. And after that, the opportunity for questions and answers. For those in the room, you can just speak as if Katharina was in the room. She should hear you clearly. For those joining online, could you please send or make your questions available via the Q&A opportunity on Zoom. I'll also monitor the chat, but if possible, please do use the Q&A. That's easier for us, and then I'll read out your questions. So that said, Katharina, very, very welcome, very, very warm welcome, and at some point we very much hope to have you here in person. We're very happy to have you here online, and I'll hand over to you. We can already see your slides clearly, and we are looking forward to your talk. Thank you, Katharina.
Well, thank you, Felix and Louisa, for the kind invitation to present my book in your seminar series or speaker series, which I have accepted with great pleasure. I would have loved to come to Cambridge, but some of the logistics didn't quite work out this time, but I'm really happy to be back in Europe. I'm actually in Ivrea, a little town north of Turin. I went to the book fair in Turin to promote the Italian translation of this book. I'll show you the cover later on. And I'm off to Rome for this afternoon, so it could be worse. So here's the story of my book. The core thesis is that capital is coded in law. There are many definitions about what capital is. I basically go with a relatively common one, that capital is a wealth generating asset, but then this raises the question of what generates that wealth. And it's just not anything, it is the law. It's the institutionalized means of coercion, how I define what the law really does to transform or flip a simple good idea claim into a wealth generating type of assets. So capital has certain attributes. So I'm basically came to these attributes by reverse engineering, just looking at the capital assets that are around, that have been around. Land was the most important one. I'll talk more about this in a little while, financial assets, and ask myself, what is it that gives them the wealth generating capacity, also the wealth protecting capacity? They go hand in hand. And here are the 4 key attributes, and you need 3 out of 4 to become a capital asset. So critical is ranking, so that a claimant has better rights than others over the same type of assets. So very often you have competing claims to the same asset. So you have to allocate priority rights. And of course you do this, for example, in bankruptcy. And we do this outside bankruptcy through property rights or collateral law secured transactions and the like. So priority over others is key to have the best chance of creating wealth. The second attribute is durability, which is basically the extension of certain rights to assets in time, mostly by excluding too many creditors to put their hands on those assets. And we achieve durability through mechanisms such as the common law trust or the corporate form that separates different assets and makes it harder for creditors to cut through and get to all the assets that might somehow be related to a particular a debtor, but are shielded by legal devices. The third attribute is very close to what durability does, but it works primarily for financial assets. It allows you to convert a particular asset into another one, hopefully a more safe or a safer asset, and thereby also lock in past gains. So for financial assets, durability is not so important. What they really want to achieve is to, once asset values decline, to flip the assets into safer assets, in the last instance into state money, cash, because only state money will retain its nominal value, not its real value, but its nominal value in all crises, whereas private assets all lose their assets or mostly lose their assets in those times. And last but not least, all these claims that we negotiate or take for granted because we have coded an asset with property rights that basically by law, without further bargaining, give you certain privileges, you want to make sure that all these types of legal entitlements and privileges will be enforced against the world, erga omnes, against anybody, not only against contracting parties. And that's what the law does. That's sort of the beauty of legal coding. Over the past several centuries, and that was sort of the most startling sort of insight that I gained by looking at these issues, is that we have basically used a relatively small set of institutions derived mostly from what we call private law or sort of commercial law, transactional law, the common law, to code assets as capital. So it's not a huge range of legal devices. You could use others, but here are, I think, the core ones that we have used time and again: property law, collateral law, or secure transaction law, the common law trust, corporate law, bankruptcy law, and contract law. Now, contract law is special because it sounds like it's mostly bilateral, but of course, first of all, contracts are protected against third-party interference. And you can also mimic some of the characteristics of property law and collateral law, also business organization law, through contract. And with modern information technology, can almost replicate the erga omnes, the universality feature, by contracting at the same time with the same standard contract with millions, if not billions of people, if you look at the big tech companies. And we all click agree, enter into legally binding agreement without even knowing what they will entail. So what I do in the book, essentially, and since we have limited time, I just don't think I will go through any of the specific applications in the book, but I would be happy to return to them in the Q&A. What I do in the book, I'm basically using different types of assets. I call them assets, but these are goods, resources, claims, ideas that have been coded as capital over time. It all starts with land. I think there's a large agreement about this, lands, but also firms, debt, and know-how. And I'm not saying that there has been a sequence, first land and at the end know-how. It went in parallel, although land was dominant until probably the late 19th century, certainly in Britain and many other countries as well. So I think what is important to realize is that behind my argument, there's a certain conception of law. I follow Max Weber, who basically argued that the modern nation state has centralized the means of coercion. I also argue that coercion is critical for law. There is a literature now out. I discuss Gillian Hatfield and Barry Weingart's paper on what is law in my book, where they question whether you really need coercion. They basically say you can have a legal system without centralized coercion, just by coordinating market participants to exercise their own enforcement powers, for example, by excluding or shunning, boycotting fellow market participants. But you still need a central authority that announces what the rule is, and how this authority becomes the authority is not further explained. But I really think when we are talking about scalable and highly scaled economic and financial systems, a global financial system, the fact that you have a claim that is in principle ultimately enforceable is absolutely key. Otherwise, a claim to pay a couple of millions, trillions, billions dollars in a couple of days or have even overnight is an empty claim, unless I have some kind of legal device to protect this. That's how we have configured our economies for centuries. The digital coding might take over. I have a chapter on this in the book as well, but so far it's the law that does that. But even if we concede that the law represents basically the institutionalized version of the centralized means of coercion, it does not follow that access to the centralized and consolidated means of coercion is also centralized. We have, especially in the common law, but more generally in private law, with access to the judiciary or to arbitration, we have created a legal system that allows highly decentralized access to the means of coercion, because you can bring claims and you can enforce the law against others in that fashion. And so gaining access to the means of coercion through procedural law, of course, but also the substantive law is quite critical. So what the legal system essentially does, and that's what I'm focusing on in this book, it does other things as well, it regulates, but what the legal system, the core private law does for the purposes of my book is it determines basically who has access to the means of coercion, how and for what purposes. What purposes is basically the substantive law. Lay people, of course, associate law very often with a state dictating, regulating, punishing in a vertical fashion from top down. I'm mostly interested in this upper left-hand corner, thinking about the relationship between private parties and the use of private law and the civil courts, the private courts, to not all of systems separate them, but using the courts to settle private disputes, and even in the shadow of just the possibility to use these courts, you can transact with a reasonable probability that whatever you have devised in transactional law will be enforceable in a court of law. So what determines ultimately whether you have a chance to access the means of coercion and make your claim are, of course, standing rules, as we call them today. So pleading rules in the English system, whether you are individual or collective. So during the enclosure movement in England, some commoners lost the case because the courts would not accept cases that were brought by a collective, because they protected only individual rights. Or whether we allow legal persons to claim is a major move in legal history. Of course, not only natural persons. That empowers corporations to use a system, access the coercive means of the centralized means of coercion for their purposes. And the next question, of course, is what rights are permissible? Not every right can be defended. Do you have property rights or not? Do you just have a use right? Maybe a use right doesn't give you the possibility to make a damage claim in tort cases or to raise other issues. Contracts, injury to persons' assets, but what kind of assets? All these things that lawyers, of course, are dealing with every day. I'm just trying to abstract from the nitty-gritty details of the law and basically say, what are the underlying principles here? We have a legal system, the procedural law and the substantive law determines who may access the consolidated means of coercion for what purposes. And then, of course, last but not least, what is also important to create incentives to sue or not to sue are the remedies that might be available, whether you can use what Calabresi calls property rules, you can stop people from doing this or enforce, seize your assets, or whether you have liability rules. Trying to get compensation, and depending on what your real desires are, this might make a difference whether you will sue or not. What I also want to emphasize, and lawyers of course know that, but non-lawyers are less familiar with this, especially economists very often seem to assume that property is a fixed thing. You just allocate property rights and then the market does the rest. And in fact, when you look at legal history and even contemporary legal development, you see that law is highly malleable. It changes its meaning over time. So for property, we have gone from use rights, using mostly tangible asset, particularly land, to protecting expectations as property, and to protecting, even in the financial world, the probability of realizing certain expectations as property. And we give compensation if these rights were violated. So I just put this on below here. Use rights were associated with land. Then in the late 19th century, American courts in particular started to protect business organizations as going concerns, and they received compensation for expropriation if, for example, the government or the local municipality would build a road or interfere with their property rights in other ways. And last but not least, we see this with financial assets as well, which are really just an expectation that there's a probability of an expectation that you can realize something in the future, which obtains nonetheless almost protection akin to property. So what property is of course nowhere really defined. It's nowhere defined in written constitutions, and it's typically assumed rather than explained, and that gives you the wiggle room as a lawyer to push the boundaries of what should be protected as property. This is a picture I got from Piketty, Thomas Piketty's book, Capital in the 21st Century. So his first major book that came out in English in 2014. And this graph was also one of the inspirations for my book, because he explains and he shows you with the data that he has, we can dispute the data, but the data that he used showed that a particular type of capital in rural land, which is the black box here, the black field here on the bottom, was the most important source of wealth, certainly in 1700, and then declined in England rapidly after 1881. You can't see really 1881 here, but that's the key date when the Land Settlement and the Land Conveyance Act were changed and radically changed the law of realty in England. Other sources of wealth are housing, which increases over time in the 21st century, in the late 20th already, and other domestic assets are mostly financial assets, shares, bonds, and other things. He calls this the metamorphosis of capital, and as any good economist, he explains it with changes in demand and supplies, changes in technology. And I looked at the graph and said, it's all about the law, stupid. It is the law. And for England, the graph is really, really interesting, because I think after the Depression in the 1870s and with the enactment of the Land Conveyance and the Land Settlements Act of 1881, the law of realty was dramatically changed. And it basically cost the landed estates durability. What happened? Essentially, the law said that they would no longer allow basically the owner to posture as only a live tenant, but they would treat him as a real owner so that the creditors could enforce against secured assets, and maybe not the family mansion without court approval, but otherwise you could get the assets and enforce against them. And about 20% of land in England changed hands after that legal change. So land is still a property right, of course, but it has lost durability, which is one of the key characteristics, attributes of capital, as explained earlier. So since we are in the UK, I also want to quote Bernard Rudden, the late legal historian and also Soviet law expert, whom I encountered when I studied Soviet law at UCL back in 1988. His writings, I never met him in person, but I came across another paper of his, which I also was an inspiration for this book. Basically, it's a variation on this theme as the entire book, and in which he said, the traditional concepts of common law of property were created for and by the ruling classes at a time when the bulk of their capital was land. Nowadays, the great wealth lies in stocks, shares, bonds, and the like, and is not just movable, but mobile, crossing oceans at the touch of a keypad in the search of a fiscal utopia. Now it comes. In terms of legal theory and technique, however, there has been a profound, if little discussed, evolution by which the concepts originally devised for real property have been detached from their original object, land, only to survive and flourish as a means of handling abstract value. The feudal calculus lives and breathes, but its habitat is wealth, not land. And that's what capital is all about. It's basically detaching the legal devices that were created during the feudal era and applying them to new assets. Financial assets are big, of course. Now we have sort of another generation of financial assets, green assets we're morphing over time, but to use the same kind of priority rights, the durability features, the universality to protect them against others. In short, capitalism is a market economy, but a market economy on legal steroids. And you wouldn't have the kind of wealth generation without these legal steroids. So, as I said earlier, law is malleable. Thorstein Veblen, one of the old institutionalists who wrote in the turn of the 19th to the 20th century, called them the working rules of society. Most people, when they think about law, think about legal change that happens through major events, which could be either new legislation or new precedent. Everything is marginal, everything else is marginal, it doesn't really change the law. And yet, as Catherine Thelen and her collaborators have shown in a series of articles, the accumulation of marginal change can actually fundamentally alter the law. And as lawyers, when we read their work, we're not surprised because we constantly deal with the interpretation of precedents or statutory law when we apply them to new fact patterns. We're constantly adapting the law. That's a feature of a law for a living society, in particular for a dynamic economic system that works by market principles. We're using analogy, we're using gap filling. And all of that, of course, when private attorneys are doing this, is done in the expectation that these changes will be recognized by the courts. This is why they study the court rulings and make sure that they're largely compliant with what has been said by them, and just push the boundaries, a little bit in favor of their clients. So we have expanded assets. I've said this before. We moved from tangibles, land. We moved to intangibles that have their very origin in law itself. So what is really fascinating, I think, in our world today is that when you look at market capitalization of listed companies, etc., intangible assets are very often the largest share, right? The trademark, the patents, and what is patentable or what can be recognized as especially if copyrights and other, or how far we push trade secrets has expanded over time, which of course then increases this value. But whether or not we recognize something as an intellectual property rights is entirely a matter of law. For land, people still think, well, that's land, it's a real thing, the law is just adjacent or marginal to it. When in fact, of course, the use of land as a capital asset is just as dependent on the law as intellectual property rights. So in our world today, we basically have configured a system where if you know the law and you know how to push for new intangible types of assets, you can actually create the very assets that are protected in law and therefore create value. And of course, the major shift that we've seen in the late 19th century was globalization. But globalization is also not just an economic phenomenon. It's certainly not a phenomenon whereby the state retreats. It's just a phenomenon where it has become easier for private parties to pick and choose the laws by which they wish to be governed and to protect their assets under different types of legal systems, even if they still remain in their home country or do business simultaneously in multiple jurisdictions. So without that system in place, and of course the lawyers in the room know this is, I'm talking about choice of law, conflict of law, international private law, these are the terms we use for them. We have created the assurance that law becomes portable. I use the laws from here, I create a corporation, it will still be recognized elsewhere, right? Similarly, we have expanded the option to have disputes settled in different jurisdictions, not exactly by courts. We're still reluctant to simply enforce foreign court awards, but we do enforce without checking the merits arbitration awards. And so arbitration has become an important aspect of it. And of course, through knowing which laws to choose, how to make foreign choices in advance, and relying to some extent also on international treaties, especially bilateral investment treaties and trade treaties, we have expanded the use of the coercive means of enforcement. It's a patchwork. We don't have a global state. We don't have a global enforcement apparatus, but by knowing under what conditions we have access to what legal system, we can replicate this, and even in a much more flexible fashion, which of course supports those who know how to use this and have the resources to pay the lawyers who know how to use this. So I will skip this because I basically said what I want to say. I want to get to this slide. On the right, you see the Italian cover, or the cover of the Italian book, Il Codice del Capitale, with the lawyer. So the big question, of course, at some point when you look and show in the book how different assets have been coded time and again with the same legal devices to become wealth generating assets, then you have to ask the question, who's done it? And these are the lawyers, and in particular, the solicitors in England, or the attorneys in private law firms that do the transactional work. They need to know the law. They have to master law's malleability. They need to know the flexibility, how to use it to advance the interests of their clients. They have to have the ability to translate economic interests into legal categories. but also to repurpose legal categories for economic interests. And that's probably even more important than the one before. They have to be creative. They have to be persuasive because they're constantly on the phone, not only with their clients, but also with regulators, tax authorities, etc., to preempt any regulatory intervention with sort of new coding strategies that they might have. At least that's what lawyers in New York do, and I'm sure in London as well. And they therefore also must have somewhat elastic ethics, I would say, because they're not only bound by the law, they're also very much bound by the interests of their clients and, of course, by the fees that they generate from serving them. So when people talk about globalization, they typically think about the global financial centers, foremost amongst them New York and London, others, of course, Singapore, Hong Kong, a little bit shaky, Shenzhen, Shanghai might take over at some point. But we have some competitors still. I think most data that I've seen still say these are the major financial centers. But these are also, and that's my point, they're also the centers for coding global capital globally. So these are where the biggest law firms are. Global law firms are defined as firms that have offices in more than one jurisdiction. And you see the biggest firms that serve global clients and have multiple jurisdictional operations. They sit in London and New York. And if you don't believe me, here are some data just to show this. These are the latest data I could find. It's basically profit by partner. All of these firms are really Anglo-Saxon. One exception is Denters Verein, but Denters is a merger of Anglo-Saxon and American firm with a Chinese firm using a fine structure. It's called Chinese, but I think it does fit in the pattern. And when you go down to the top 100, you still have the same pattern. So effectively, globalization is the globalization of Anglo-Saxon legal practices. In the book, I also discuss how much they have, how much market share in key areas such as merger and acquisitions, capital market law they have gained in Germany and France, the classic civil law jurisdiction. So that's another just data point to make the same case. So I might be a little faster than you expected, but I think I talked probably for 25 minutes, but I thought I'd rather bring make my case and then respond to questions. So my concluding thoughts are here: it takes law, it takes a legal system, and better more than one to code capital. So in England, I think also the competition or the duality of the common law courts and then the chancery courts was critical to create these new institutions such as trusts and use equity principles to overcome some of the rigidities of the common law. In the US, it's the competition between different states that are the lawgivers for all the private law we're talking about, property rights, trusts, corporate laws, all state-based. And the regulatory competition among states was really key for pushing the system to the most favorable state from the perspective of capital. I would also assert, of course, that an economy based on private initiative, market economy, depends on adaptive and malleable law, because you have to constantly adapt what the law really means in new circumstances. And so you also have a reason, a case for these lawyers doing their job. The question, of course, is always, where do you stop? Where are the boundaries of this? And we can look at multiple examples that even attempts by states to really make sure that for certain essential aspects of the law, they have the prerogative, such as property. Anything that is located in my territory, I will set the property rules. Then you confront financial assets that don't have a location. And all of a sudden, of course, you're creating new kinds of points of connection under international private law that say, oh, well, maybe it's enough to think about where the asset has been issued. And since you can choose the place where you incorporate an issuer, then you can also choose the place for property rights. So all of these constraints are pushed and over time give in. My final point, and I discuss this in the book at length, I think we have a system where we have capital is coded in law in the institutions of private law. It's backed by a social resource, which is the legal system, which is based on the legitimacy of law and legal institutions and the enforcement apparatus. We also have a system that is called democracy, whereby people who belong to a particular jurisdiction, country, nation, if you wish, govern themselves through legislation, of course, also the court system, regulatory system. And I think that we have, pushed the ability of private parties to pick and choose the laws by which they wish to be governed, the ability to refashion law in the name of capital interest, to a point where we are in danger of eroding fundamental principles of democratic self-governance. And so my last chapter in the book deals with possible strategies to push back and regain more space for political decision-making through democratic legislative processes, but also through constraining actors in outsourcing the law too far. So that's it from my side. I'll just stop sharing so I can see you better, and thanks for listening.